You were charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On July 5th, 2022, the complainant told officers that the defendant was terminated for intoxication and attendance issues. The complainant believed that it was clear to the defendant was not to return to the physical location of the business. The defendant returned a few weeks later requesting money from an employee, spoke with a manager to say his termination was not fair, and the defendant approached employees while they were on break, and employees stated the defendant was making them feel uncomfortable. The complainant told the defendant not to come back to the property, and the defendant stated he understood. Approximately a week later, the complainant was walking to his vehicle in the parking lot at the location and saw the defendant inside his vehicle. The defendant had snapped the side view mirrors off the vehicle.
So just a trespass, no. Right. Mr. Wood, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to go back to this location. Do you understand? If I find that you violate these conditions, if you pick up a new case, I will revoke your bond, put you in jail. No more PR bonds for you. Your bond amount is set at $100 now. So he has not made bond, right? Okay. I will give you a PR bond today, Mr. Clark. I'm sorry, Mr. Wood, but I'm not going to give you another one. If I find that you're a danger to my city in any way, I don't care. I have a place for you. Do you understand?
Yes, sir.
So for now, what I'll have you do is, do you have a lawyer today?
I do not, Your Honor.
Do you have the ability to hire a lawyer?
Do not, Your Honor.
Okay, I can have you fill out an application for a court-appointed lawyer. I'll take a look to see whether you qualify. I need to know everything about you, how much money you have in the bank, what you do for a living, any source of income, what kind of car you drive, money in the bank, stocks, bonds, IRAs, mutual funds, anything.
Got documentation.
Okay, well, no, I need you to fill out my application.
Yes, sir.
And then I'll have you sign a receipt with Victoria. We'll have you take your seat in the jury box. Do not leave until you sign our bond conditions, okay?
Yes, sir.
Okay, come on. So can you file, no going back? Good morning, Ms. Rodriguez. Ma'am, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On March 4th, 2025, the officer was dispatched to a minor accident at 1700 block and arrived. The officer made contact with a witness who stated she heard and saw the defendant with a driver saw occupant of the vehicle and sideswiped a parked motor vehicle. The officer noted the vehicle was parked incorrectly facing the opposite way. The witness stated she believes the defendant is intoxicated, and the defendant stated she hit the motor vehicle while driving as she took her eyes off the road when trying to retrieve her cell phone, which fell to the floor. The defendant stated she remained on scene because she wanted to make it right with the owner. The officer observed slurred speech and swaying, and the defendant admitted to having drinks earlier in the day. Standard field sobriety tests were conducted and the HGN test was began, however, was suspended at the defendant's request due to high winds. The defendant was placed under arrest for suspicion of DUI and was transported to the jail. Standard field sobriety tests were then conducted at the jail. HGN 6 out of 6, walk and turn 7 out of 8, one leg stand 3 out of 4. The defendant was read DIC and consented to provide breath. The first sample came back deficient and the second sample came back unacceptable. A blood report was signed and executed.
Well, ma'am, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. You will be randomly tested. If I find that you're consuming alcohol or any illegal drugs, your bond will be revoked. You'll go into custody. I'm also now placing a restriction on your license. You're not allowed to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, then likewise, you will go to jail. We send notice to DPS of this restriction and this requirement so that if you're caught driving a vehicle, it doesn't matter where it is. Every officer in this state will know that you're required to have an interlock. So if you're caught driving a vehicle, they will arrest you. You've got a great lawyer here. Listen to him. He'll take care of you. Because you have him, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with him. He'll tell you when you have to come back to court. For now.
She's already had the interlock installed.
Wonderful. Okay. So you're just not much of anything. Just stay in contact with him. He'll tell you what to do. We'll just have you sign a reset and then you're on your way. Okay. Thanks. Good to see you, Enrique. So you're going to dismiss the failure to ID, I would.
Yes.
Okay, so Mr. Veach, you're charged with 2 cases. You're charged with failure to identify oneself You're also charged with theft. You have worked out an agreement where they're offering you 9 days in jail with credit for the 9 days that you've done on the theft case. As part of that plea bargain agreement, the other case will be dismissed. Is this how you understand it? You need to understand, Mr. Veach, that this is an enhanceable offense, meaning that if you continue to pick up these types of cases, then you will be charged with a felony. And then you will be looking at, in fact, you have one prior. So you pick up another one, you'll be looking at years instead of days. Do you understand? Because 2, 1, and 1 make 2. 2 plus 1, 3, a third is a felony.
Right.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, there's no turning back. It will go on your record. It'll be there forever. Is this what you want to do? How do you plead to the offense? I'll find you guilty, send you to it. Good luck to you, Mr. Veach.
Thank you.
Thank you, Judge.
Good morning, Mr. Machado Santos. Sir, you're charged with possession of a controlled substance. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 12 days in jail with credit for the 4 days that you've done. You need to understand that this charge will go on your record. It's going to be there for the rest of your life. From now on, you're facing a minimum of 90 days in jail for any new cases that you pick up here. You understand?
Yes, sir.
Are you on probation or parole at this time?
Yes, sir.
Okay. If you are on probation, if you are, it can result in further confinement by pleading guilty to these offenses. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it will go on your record. You can never take it off. This is what you want to do.
Yes, sir.
So how do you plead to the offense? I'm going to find you guilty. If it's enhanced, it'll be abandoned. Good luck to you, sir. Thank you, Mr. Lynn. Thank you.
There you go.
Good morning, Ms. Lynn. And you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Yes, Judge. On March 9th, 2025, at approximately 11:29 p.m., the officer was dispatched to a wrong-way driver call at 1623 South US 59 Freeway in Harris County, Texas. Upon arrival, the officer observed a vehicle stopped in a moving lane of traffic with multiple tow trucks around the vehicle in an attempt to box the defendant in. The defendant's vehicle ignition was on and the vehicle was in park. The officer made contact with a real witness who stated they saw the defendant's vehicle traveling southbound on the northbound side of South US 59 and that he and other tow truck drivers boxed into the defendant's vehicle at 4800 Main Street. The officer observed the defendant to have an odor of an alcoholic beverage, swaying and stumbling. Bloodshot eyes and disorientation were also observed. The defendant admitted to drinking 6 drinks at the Houston rodeo and stated she was 4 out of 10 drunk. The defendant refused standard sobriety test. The defendant was read to DIC and the defendant refused to provide a specimen. A blood search warrant was signed and executed.
You can look her up to see if she has any prior DWIs.
She
Number
knows
one.
she had no prior and went to
Okay, Ms. Lynn, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand? Now you have a lawyer. They will take care of you. I will waive your appearance because you have a lawyer, but it is your responsibility to stay in touch with them. If they tell me you've gone AWOL, you pick up a new case, become a danger to my community. I only have one place for you. Do you understand, man? Okay. We'll have you sign a reset with Victoria. You'll get with Felicia for your bond conditions, and after that, you're free to go. Okay? Thanks. Sir, you were charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 6 days in jail with credit for the 2 days that you've done. You need to understand something very important, that this will go on your record as of today, and it's going to be there for the rest of your life. You can never take this off. From now on, you'll be facing a minimum of 90 days in jail for any new cases that you pick up. Do you understand? So you give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So there's no turning back. Once you plead guilty, it's on there forever. Is this what you want to do? How do you plead to the offense? I'm going to find you guilty. Was it a gun?
Yes, the firearm.
The weapon will now be forfeited to the state. You will not get it back. Do you understand?
Yes.
Okay, good luck to you, sir. Or how do you plead?
Guilty.
I'll find you guilty, sentence you to it. Good luck to you, sir.
Thank you,
Thank you, Josh.
Question?
You can run it.